The next case is ACAB LLC and ACAB Series LLC, appellants versus Michael Murray and others, respondents, case number 77050. Mr. Wall, Mr. Greenberg, I think you were present in court when I indicated the court's mask policy and the fact that counsel would be urged and be perfectly acceptable if they removed their masks during argument. All of the justices have been vaccinated, so consistent with current CDC guidelines, I wanted to inform you of that, and that is why we are unmasked on the bench. We, consistent with Supreme Court policy, however, and because the court is unable to engage in the process of trying to determine who's vaccinated and who isn't vaccinated, we require masking in all public areas within the courthouse otherwise.
Thank
Are you ready to proceed, Mr. Wall?
Yes, Your Honor.
Okay.
Chief Justice Hardesty, Associate Justices, may it please the court, my name is Michael Wall. I have the privilege and honor of representing today ACAB. Mr. Nady, who is the principal of ACAB, and his wife are with us present here in the courtroom. I have with me Esther Rodriguez, who was trial counsel with me and is appellate counsel with me. Primarily, this case is about a granting of summary judgment that was inappropriate. The real problem with this case, and I hate to say it, is that I believe that the district judge became so involved in enforcing the Minimum Wage Act that the judge forgot to pay attention to the rest of the Constitution, including protections against or protections of due process of law. Primarily in this case, the district judge put the burden of proof on the proper party, the plaintiff, throughout the litigation for 5 years, going on 6. And we were up against that deadline, and the judge decided at that point in time, somehow it became ACAB's burden of proof to prove that they had paid a minimum wage. This case was always about, in the pleadings, a claim that ACAB had required the cab drivers to keep false trip sheets. There was never any evidence of that whatsoever during all of the discovery and during all of the case, because that really wasn't what the case was about. Generally speaking, they were just looking for a minimum wage, and Judge Corey was convinced, even though there was no evidence, that ACAB had not paid a minimum wage and didn't require proof of that, and instead was looking the entire time for proof of the damages. And the proof of those damages is contained in the trip sheets. That's where everyone keeps their records. All of the cab companies keep those trip sheets, and every piece of information necessary to determine whether or not a minimum wage was paid was in the trip sheets. That was said in every motion paper, in every pleading, in everything that was filed, and at every hearing for 6 years. And the Judge Corey agreed with that the entire time. You had to be able to go through those trip sheets. Instead, we went through an extreme amount of discovery where we were required to produce all kinds of things that had nothing to do with minimum wage. And after producing those documents, they were never even looked at by the plaintiffs. That was admitted at the hearings at the end. They never even looked at it. It was never their intention to prove their case. It was always their intention to be able to win the case without having to prove it. So we have a summary judgment that was granted when there was no motion for summary judgment pending, when the only basis for damages was a basis that the Judge Corey himself had declared on at least 3 separate occasions was an unreasonable basis, a basis that didn't work. And he didn't grant summary judgment because there wasn't an issue to go to trial. He didn't grant summary judgment because there was a statute under which one party was entitled to judgment as a matter of law. He granted summary judgment as a sanction against ACAB because ACAB claimed not to be in a position to be able to pay for, on the eve of trial, analysis of the documents that had been produced at the very, very beginning of this matter, and which should have been analyzed by the plaintiffs. The plaintiffs may claim that there was problems with the expense of doing that analysis. Whatever their claim is, they could have hired outside of the country services that are available and had these documents reviewed. They could have reviewed them themselves. They could have approached it in that way. They brought a motion right at the beginning for the appointment of a special master to do that work, and the
Mr.
judge
Wall,
denied
was
it.
it your position that the trip sheets that were produced for the 2007 to 2013 period complied with 608-115 and Corey got that wrong?
I'm sorry, Your Honor.
Did they comply? Like,
Yes.
how they were supposed to, you said
The trip sheets comply with the statute. The statute does not say how you have to keep the records. It just says that the records have to be kept. Every employee got their pay stubs. Every time the pay stubs were retained, those had the information on them, how many hours they worked and how much they were paid. All of that is reflected in the trip sheets. But the judge used that as a hook at the end to say, well, you didn't keep records pursuant to the statute that were sufficient under the statute, reading the statute in a very narrow way, which the statute was never intended.
Did the trip sheet show the total number of hours employed in a given pay period and the number of hours per day?
Yes, the trip sheet showed the number of hours that they worked every day. It showed every break that they took every day. They showed how much they were paid. Every piece of information, as was admitted in opposing counsel's pleadings and motion papers, the information was there. The position that was taken at the end was, we didn't have to go and get that information. You should have handed it to us in a simpler format.
So I just want to understand, though, my understanding, and please correct me if I'm wrong, because this is really important, at least from my perspective, that the trip sheets were showing the time the person started working, the time they stopped working, and the times they took breaks, but it didn't have the total number as a particular entry on the trip sheet somewhere, so that instead someone would have to go through and say, okay, they started at 9:45 and they finished at 7:20, so I have to figure out how many hours and minutes that is. So is that accurate?
That's accurate, Your Honor. You would have to take the information from the trip sheets and calculate amounts for any given pay period, and that was done all the time. If a cab driver came in and needed that information, it could be calculated for that cab driver in minutes and provided to him. The information is there, it's not calculated out.
So if the pay stub actually showed the number of hours, but that information wasn't kept, so that couldn't just be provided, and say for this period of time they worked X number of hours?
Pay stubs were kept and were provided along with a tremendous amount of other discovery.
So there was
information.
documentation produced that showed the total number of hours worked per day and per pay period.
Let me be very careful here, Justice Kadish. I wasn't involved in the case at that point in time. I became involved after that was done.
Okay, and again,
But
I'm
I
only
can
talking
say-
about pre-2013 for the purposes of this conversation.
I can say very clearly all the information that they needed was produced, and from that information, the trip sheets and the other information that was there, it could easily have been calculated out.
If the special
It would have been a
master
big
spent the
job,
time.
But it could have been calculated out, and it wasn't done.
And that could be done by putting in the time that the special master said they needed to put in.
Well, yeah, there wasn't a special master until the very end because the judge denied that request and said it was their responsibility. But then at the very end, when the matter was coming up against the deadlines and it started to look kind of crazy and we were having hearings every day and filing hundreds of pages of documents on a every other day basis, Judge Corey, at a hearing where we were there to hear whether or not the experts should be allowed to testify or not, and to hear a motion for summary judgment that was on reconsideration for the fourth time. Instead of hearing those, he said, well, let's see, I remember years ago, there was a motion for a special master. And I'm going to, if you will renew that motion, plaintiff's counsel, I will grant it. And that's what he did, because he had come up with that idea. At that point in time, we have to analyze these documents to find out what the damages are, and we're going to have a special master to do it. And then he ordered the ACAB to pay for that process, which was a complete shifting of the burden of proof with respect to that. So
Mr. Wall, will you address the propriety of aggregation here,
I'm sorry,
of aggregation of the claims?
aggregation of claims. At the time that the complaint was filed, the law in Nevada was you couldn't aggregate the claims.
Well, under Castillo, because the statute was pretty much silent on it at the time, right?
Yes, this is,
Castillo came out, and they said you can't aggregate, but then on a motion to depublish Castillo, it seems that the court walked that back.
I don't know that the court
So-
walked it back. The court said, we don't think this is going to be a big problem. That's an unpublished order denying rehearing. The decision in Castillo was solid when it was decided. It wasn't dicta. The whole opinion has to do with where the jurisdiction was. There was a little bit at the end where we said, the district court has jurisdiction anyway, and resolved the issue that had to do with the preliminary injunction. But to suggest that that entire opinion was about that would be wrong. That opinion was about applying the law as it stood. Justice Court Rule 23 allows for class action suits. The NRCP 23 allows for class action suits. NRS 4.370 at that time set the jurisdiction of the district court and the justice court based on the amount in controversy, and the Castillo and the Nevada Constitution, Article 6, Section 6, as amended in 1978, says no concurrent jurisdiction. It's been challenged in the legislature multiple times and nothing has ever happened. The Nevada Constitution says no concurrent jurisdiction.
But if we were to decide that you aggregate them, and if you aggregate them and it's over $10,000, then it would be in district court, and if it's not over $10,000, it wouldn't be concurrent jurisdiction.
If you had to aggregate, but you didn't have the choice whether or not to aggregate. And that's the
No,
question.
of course, you can't have the choice. Either the law says you aggregate under class actions or not.
And the question is, if the law in Nevada, right up until the change in the rule, which happened after the judgment was entered, after Judge Corey had denied the motion to dismiss, after that time, the rule was changed to allow aggregation. Assuming
It was changed and it now specifies there's aggregation. I don't believe there was any statement about whether it previously allowed it or not.
That's right. It was silent, apparently silent on it before. It didn't say anything about aggregation, but the Castillo court, considering that, recognized that if there was aggregation with the two rules in existence, there would be concurrent jurisdiction. There would be the case where the parties could choose to go to justice court or to go to district court, and the Nevada Constitution doesn't allow that.
So you're saying, Mr. Wall, you're saying that if none of these other issues were involved in this case and only there was a jurisdictional issue, that at the end of the day with this over $1 million verdict, that this should have been in justice court. That's what you're saying.
It should have been in justice court, Your Honor, if at all. And the fact that the rule was changed after Castillo was decided should not affect the jurisdiction in this case. You can't go after the fact and say that when the case was filed, there was no jurisdiction. When the judgment was entered, there was no jurisdiction. A rule change has come about, and now we're going to reanalyze this and decide whether or not there was jurisdiction. When this issue was brought to Judge Corey, he gave it no analysis whatsoever. He just simply said, oh, I don't think I don't have jurisdiction. That's what he said. And that was the decision that we got.
Do you agree, Mr. Wall, the language in Castillo about aggregation was dicta in light of the holding?
Would there be enough of...
In light of the holding that was based on the injunctive hook, do you agree that the language in Castillo about the aggregation of claims or prohibiting aggregation of claims is dicta?
I don't believe that that's dicta at all. I think that dicta is when there's a stray language in an opinion that really wasn't being talked about, and that language then later on comes back to haunt us all because it wasn't thought out.
Apparently the justices who agreed and signed on to that opinion thought it was dicta.
They said in an order denying rehearing that it was arguably dicta and we didn't think it was going to have the consequences that you suggested, therefore we deny rehearing. Rehearing is denied if you raise something that has been raised.
It was on a motion to
or something that hasn't been
depublish.
raised.
It was on a motion to depublish. It wasn't on rehearing.
It was, that's right, sorry. It was a motion to publish, and the court refused to publish it. So it is not a
Refused to
published
publish.
decision, that's right. I'm sorry, I forgot there, I was a little confused about that. Sorry about that. Still, the standard there was whether or not they were gonna change, and the court said, it's arguably dicta, and I think that's incredibly wrong. Because using the word dicta to do away with language we no longer like is the wrong approach. If you don't like the language, you overturn the language. In that case, the primary discussion in the case was whether or not there was jurisdiction based on aggregation. The fact that we can find some other justification which upheld the district court's jurisdiction does not make that not the primary decision. It was considered by the court. That court addressed it on its merits deeply and came to the correct conclusion that as the law stood at that time, there was no jurisdiction in Nevada because you couldn't aggregate the claims. Now, if that's wrong, we should say it's wrong, not by labeling it dicta. And if it was wrong, and we say it's wrong, it shouldn't be retroactive. The law at the time was the district court had no jurisdiction. I'm out of time. Thank you, Your Honors.
May it please the court, I'm Leon Greenberg. I am arguing today on behalf of the respondents. In a minimum wage case, all we need to know is the hours the individual worked for the week and the wages they were paid for the week. We have those two pieces of factual information. Damages, if any, flow as a matter of law, of strict arithmetic. And I think we all understand that. The issue in this case, in terms of the approach taken by Judge Corey that appellant's counsel is taking issue with, is somehow shifting the burden to the employer here, the defendant, wasn't a burden of showing that they didn't owe minimum wages. It was a burden the law imposes upon them to keep accurate records so that a finding can be made by the court as to whether minimum wages, if any, are owed. And that was the problem that Judge Corey was confronted with.
I don't think I understand that problem, Mr. Greenberg. So I wanted to ask you today, what precisely was the problem with respect to the production of documents pre-2013 that prevented you as the plaintiff from calculating damages? They produced trip sheets, they produced payroll information. What was the problem? I am really surprised that this matter got converted to a summary judgment without even a motion on the eve of the running to the 5-year rule. What was the problem, and in what respect did the production provided by the cab company fail to meet the requirements under the rule for you to calculate the damages in this case?
Your Honor, I want to just make clear to Your Honor of the court that when we talk about the deficiency of the records, we are only referring to the period before 2013. From 2013 to 2015, there was a long pending motion for partial summary judgment for about $174,000, which was granted based upon there being no dispute and an admission by ACAB that they had produced the records.
I didn't ask you about the second period, I asked you about the first.
Thank you for that clarification, Your Honor. In respect to answering Your Honor's question, the problem, Your Honor, is that the statute, 608.115, is very clear in its language, which is that the employer must maintain a record of, and I'm quoting at section 1D of the statute, the total hours employed in the pay period by noting the number of hours per day. Okay. Now, what we really need to know here is the total hours per pay period per week and the total wages paid, as I was discussing before. That record, Your Honor, was not kept. When we talk about the trip sheets.
No, but wait a minute. The trip sheets were produced pre-2013, correct?
Correct, Your Honor.
And the payroll records were produced pre-2013.
Correct, Your Honor.
Why don't those records enable the plaintiff, or the special master for that matter, to calculate the number you're trying to reach?
The special master could have done that, Your Honor, and we would have been satisfied with that. In fact, Your Honor, we could have proceeded with a statistical sample of those records, and that was suggested by myself to the district court. ACAB did not elect to do that. Judge Corey elected to appoint the special master. The cost would have been about $180,000 by the special master to collect that information, so we would know how many hours were worked in each period, pay period based on the trip sheets. The testimony of the 30B6 witness, Your Honor, for the later period, 2013 to 2015, is that ACAB actually did undergo that process. They changed their procedures as a result of investigation by the United States Department of Labor and directions from the U.S. Department of Labor that they needed to maintain those records. This actually goes back to their admonition to them in 2009. So they did actually undertake to do that at one point, Your Honor. And when this litigation started, they could have done that. They didn't have to wait until Judge Corey decided to.
So let me return
Yes,
to
Your
my
Honor.
original question. To what extent were the document requests that were submitted to ACAB and that they responded to a failure to satisfy the statutory documents that had to be maintained? I don't see the failure.
Well,
And
you-
that seems to be a central piece of Judge Corey's determination that this was basically a sanction.
Your Honor is absolutely correct that Judge Corey disposed of this case based on the failure to keep the records in
Yeah.
compliance with the statute. There was no
Yeah.
question about that.
So if we're gonna resolve this portion of the dispute, which has created this amount of liability here, I'm trying to understand how the records that they produced were deficient from the requirements of the statute.
Well, Your Honor, probably the best way to illustrate this would be to actually examine one of the trip sheets, which I have here. And
Okay.
I could approach Your Honor, or I could refer you to the record, which is at Appellant's Appendix 5318 and 5319. That is an actual 5318, 5319. That is an actual reproduction of a trip sheet that was analyzed by defendant's expert. And the record also contains at that section their expert's report. Their expert spent $47,000 to conduct a detailed review of 123 pay periods, all the trip sheets for those pay periods, to determine what was owed, what the hours were for that time period. And he actually wound up coming up with the total amount per pay period average, which is about 50% more,
Mr.
about $18 an hour. Yes.
Mr. Greenberg, prior to the 2013 records, was the number of hours per day noted on the trip sheets?
It was not. And
So
if
that's what the statute requires, is that correct?
the statute requires both a statement of hours worked per pay period and per day. If we had either of those, it would have been a lot easier to formulate what the resolution of this case should be, because the only factual issue was the hours worked. We know what these
But I
individuals
thought
were paid.
those were on the payroll,
Excuse me, the hours were on the payroll starting in 2013,
and those were not before then?
not before then, Your Honor.
Not even, nowhere on the records that were presented to you or to the court.
That is absolutely
The
correct.
number of hours worked.
There were no hours worked that were provided to us per pay period or per day in any fashion. Yes, we have trip sheets, and if we go and look at the trip sheet, there's a stamp that says when the guy took the cab out. There's another stamp that says when the guy brought the cab back. There's notes regarding break times that he took. So if we go through that, and we take those intervals and we do the math, yeah, we can sit down and figure out what the trip sheet shows about how long the guy worked that day. But actually, the testimony of their 30B6 witness regarding the 2013 to 2015 period, Your Honor, made clear that the records that they assembled in that point in 2013 to 2015 and put in the QuickBooks were actually more accurate than the trip sheets, because to quote the language of the witness, they included time that the drivers were, quote, dinking around, end quote, before and after their shift. So that's actually an admission by ACAB that the trip sheets themselves, in their entirety, don't actually reflect the full working time of the drivers, although it would certainly give us a starting place, Your Honor, if we were able to extract that information. But we were not able to do that because Judge Corey appointed the special master, directed ACAB to do that, and they declined to follow that order. And Judge Corey proceeded as he could using the Mount Clemens approach. I haven't heard any discussion from the court about the Mount Clemens approach. There was never any issues raised by appellant regarding the average hours per shift that was adopted by Judge Corey in applying that to.
Counsel?
Yes, Your Honor.
I guess along that line, did the parties, did ACAB have the opportunity to brief to Judge Corey whether that Mount Clemens approach was appropriate or not before the summary judgment was granted on that issue?
Yes, they did. And I know, Your Honor, Justice Hardesty, you had mentioned about this summary judgment issue coming sort of at this very hurried posture procedurally in the case in respect to the time before 2013. And the district court did not really grant summary judgment sua sponte here. It was requested by myself, and I will, should be in compliance with the record, acknowledge that Judge Corey had posed the question, well, why aren't we simply taking the Mount Clemens approach to the earlier time period based on the average we can derive from the later time period? And I told the judge at that time, well, that would be appropriate, but we would need to present to Your Honor the appropriate materials to base that judgment on. That was the hearing that was conducted on June 4th, 2018, and Judge Corey directed that we provide further submissions. That hearing was extensive. There was a lot of back and forth with Judge Corey about how he was going to proceed and his intentions to resolve the case. That's at the 7399 in Appellant's Appendix. And we did submit, and at that hearing, it is important to note that Judge Corey specifically gave ACAB 10 days after respondents put in those further materials to respond, and he used this term to cite authorities if he believed it was improper. That was the word he used for him to proceed in that fashion. So he gave them an opportunity to respond to the submissions that were made, urging him to proceed to enter judgment in that fashion. We did, respondents did submit those materials on June 20th and June 22nd. ACAB responded on July 10th. When they responded, and that's in the record at 8334, they did not actually raise issues regarding the application of the Mount Clemens average we proposed or the application of Mount Clemens. They simply opposed any entry of judgment for any period. They did raise an issue regarding the question of an offset for certain payments that were made to the Department of Labor that they should get credit for. And that issue was addressed, and we itemized just under $80,000 that they were entitled to an offset, and that was submitted to the court on August 3rd, 2018. That's at 8576 in the record. So yes, it was in a hurried context here, I understand that. But Judge Corey did give them an opportunity to respond on the merits, and they raised no issues regarding the form of the judgment that was entered. They did not raise any issue regarding the correctness of the arithmetic that was used. They had their expert available to analyze the Excel file that was used to arrive at the calculations that were presented and adopted by Judge Corey in fashioning the judgment. So there was no deprivation of any due process rights here by ACAB. And in respect to whether Judge Corey should have or should not have approached this as a matter of sanction, which he alternatively did, he also noted that he was approaching this as a question of striking the defendant's answer and simply proceeding to damages, still giving them an opportunity to dispute the amount of damages, but not further proceeding with the case otherwise. There was ample reason for him to exercise his discretion to do so. I mean, this court has stated that it is an abuse of discretion fashion. You look at the history of the proceedings. We have the history of the proceedings in this case back in 2016.
Mr. Greenberg?
Yes, Your Honor.
As you run out of time, can you address the tolling issue? Why was it proper for Judge Corey to require individual notice to each of the employees as opposed to the posted notice? Because that's what takes us outside of 2 years of statute of limitations, and that's why we're talking about 2007. Why was that proper?
Well, Your Honor, to quote, well, Your Honor, in the Doe Dancer case, which was decided earlier this year, this court stated that it was citing the Sixth Circuit's Amazon decision, which stated, and I quote, when interpreting state provisions that have analogous federal counterparts, Nevada courts look to federal law unless state statutory language is materially different from or inconsistent with federal law. Now, when we look at the authority that would address this issue, ACAB had a duty to advise the drivers as to the minimum wage. There's a dispute as to how that duty was fulfilled. Judge Corey, looking at the language, said that it had to be individual written notice to each driver. ACAB disagrees with that and says, well, it didn't have to be individual written notice. We know that individual written notice was not given. Was some other form of notice given? We don't know. There's no proof in the record of that. In fact, the only statement we have in the record is an allegation that there was no notice by one of the drivers, that there was no notice posted anywhere. That issue was never developed in the record. ACAB asserts in their brief that group notice was given, it was posted, and it was available, but they cite nothing in their brief supporting that. So if the court believes that the toll could be proper, as we've suggested, then there's going to have to be further findings if the court disagrees as to the nature of the notice that must be given. In respect to why the toll should be given, when we look to the federal authorities, as I was quoting, the only real federal authority we have on this is the Bonham v. Dresser case, which is from the Third Circuit, which examined the analogous provisions of the ADEA, the federal law, which places a duty on employers to advise employees of their rights to be protected against age discrimination. And there was no notice given, the statute was told, and if I could just answer by quoting the decision, they observed any other result that would be besides giving the toll to the employee's claim would place a duty upon the employer to comply without penalty for breach, and would grant the employee a right to be informed without redress for violation. There is no other redress that would be possible to cure that violation. I am out of time, I believe. Well, I don't know if you've granted me more, or I should continue.
I didn't, and you shouldn't, unless the justices have questions for you.
Chief, may I ask a question?
Yes, go ahead.
Mr. Greenberg, just briefly, you agree the Nevada Office of Labor posts the minimum wage bulletin on its website and says those notices are required to be posted in each place of business with employees. So it's required to be posted. Is it your position that there's a factual issue as to whether any notices were actually posted? Forget about individual notice, as to whether any notices were actually posted. Is that your position?
That is correct, and this is addressed in the brief, and I can give you the page number, which is on page 37 of the brief. It discusses, and at the appendix at AA 1630 to 31, you have the declaration of one of the drivers that was put in the record stating that there was in fact no such posted notice. So that is an unresolved issue.
I'm sorry.
You have the declaration of the, at AA 1630 to 31, you have the declaration of one of the drivers saying there was in fact no notice posted in the workplace as to those rights. This is an unresolved issue of fact.
Okay, that's my question. Thank you.
Thank you.
All right, thank you. The matter will stand submitted. Thank you, counsel, for your arguments and your briefing on this case, and we'll be in recess until 11:30.
All rise.